Roxanna, thank you very much for your time. So what's changed in terms of tax law since this January, and why the changes?
Under the old tax regime, a key element of any offence was that it was committed willfully and without just cause by the taxpayer. Negligence simply resulted in a mere rap on the knuckles in most cases. The new amendments now distinguish between two categories of offences. The first category, with minor offences, now require willfulness or negligence. So previously it was only willfulness that was required. The second category of more serious offences requires that there must be willfulness present. So negligence is not prosecuted in this category due to these being more serious offences. Taxpayers are urged to educate themselves of the first category of offences in particular, which now includes the element of negligence. This new element now gives SARS a wider net to prosecute non-compliant taxpayers by shifting the liability onto the taxpayer to ensure that their tax affairs are in order and that they take the necessary steps to become tax compliant.
Roxanna, what kinds of mistakes or errors that previously were handled as negligent but not willfully so could land you in trouble now?
So the Tax Administration Laws Amendment Act provides a list of specific actions that constitutes a criminal offence. Some of the most common ones that taxpayers should take note of are the failure to register your details on SARS or to notify them of any changes to your details, the failure to submit a tax return when required to do so, or the failure to disclose any material information to SARS, or failure to provide SARS with any notification as required under any tax act.
For these minor offences, what kinds of penalties could be imposed?
The criminal sanctions that may be imposed by SARS include a fine, the quantum of which will be determined by the courts upon the merits of the case, and up to 2 years of imprisonment.
That's quite drastic. Many people do their own taxes and could easily make mistakes due to either ignorance or incorrect calculations that could be construed as negligence under the new amendment. If such mistakes are widespread, would it be practically enforceable for SARS to charge all these people criminally?
Only strategically speaking, this is a bold yet brilliant move from SARS. SARS' intention here is to encourage non-compliant taxpayers to get their tax affairs in order. Yes, they have now made it much easier for taxpayers to be charged of a criminal offence. However, they have now moved this burden of proof to the hands of the National Prosecuting Authority. So even if a taxpayer is charged with one of these offences, it is still up to the courts to determine upon the merits of the case whether the taxpayer should be prosecuted or not. However, the question of whether this is practical is still to be determined. We will have to see what SARS has in store for us.
If my tax consultant makes an error, would I be liable for that mistake?
Again, we must remember that SARS' intention is not to prosecute every taxpayer based on a minor offence. The fact that SARS has passed on this burden of proof to the National Prosecuting Authority makes it much easier for SARS to simply lay a charge against a taxpayer without having to further pursue them in any way. There has been no threshold amount that we are aware of, and it does not seem that SARS intends to impose one at any time soon.
Thank you for that update. It's absolutely clear now taxpayers will all have to avail ourselves of the rules to make sure we don't make those mistakes.